Our final panel this morning will discuss the reforms undertaken by the Trump administration to improve the regulatory process. And we're particularly fortunate to have as our moderator someone who's played a key role in those reforms, Jeffrey Bossert Clark. Jeff is the Assistant Attorney General of the Environment and Natural Resources Division. From 2001 to 2005, he served as Deputy Assistant Attorney General of the same division during the administration of President George W. Bush. In between those roles, Jeff was a partner at Kirkland & Ellis. He holds a bachelor's degree from Harvard University, a master's in urban affairs and public policy from the School of Public Policy and Administration at the University of Delaware, and a JD from the Georgetown University Law Center. Please join me in welcoming Jeff Clark.
Thanks a lot, Dan, and thanks to the Deputy Attorney General, Jeff Rosen, for organizing this summit. I look forward very much to his keynote address, which follows this third panel. So we have three fantastic panelists for you to hear from today, each of whom are experts on administrative law and in particular subject matters. We have Steve Bradbury, who is the Acting Deputy Secretary and General Counsel of the U.S. Department of Transportation. Before joining DOT, Mr. Bradbury was a litigation partner at the law firm of Deckert in Washington, D.C., where his practice focused on regulatory enforcement and investigations, rulemaking and judicial review of agency actions, appellate cases, and antitrust matters. In private practice, he gained experience with automotive safety and aviation competition issues, including before DOT. From 2005 to 2009, Mr. Bradbury headed the Office of Legal Counsel at the U.S. Department of Justice, so welcome back, Steve. Before serving in the Justice Department, Mr. Bradbury was a law partner at Kirkland & Ellis for 10 years, where he actually supervised my first Kirkland assignment, so I'm gratified to be on this panel with him. He clerked for Justice Clarence Thomas on the Supreme Court and for Judge James L. Buckley on the D.C. Circuit. Mr. Bradbury graduated from Michigan Law School and received his BA from Stanford University. Our second panelist is Eric Hargan. He is the Deputy Secretary of the Department of Health and Human Services. From 2003 to 2007, Mr. Hargan served in HHS in a variety of capacities, including holding the position of Acting Deputy Secretary. During his tenure at HHS, Mr. Hargan also served as the department's regulatory policy officer, where he oversaw the development and approval of all HHS, CMS, and FDA regulations and significant guidance documents. In between his tours of duty at HHS, Mr. Hargan taught at Loyola Law School in Chicago, focusing on administrative law and healthcare regulations. He received his BA from Harvard University and his JD from Columbia University Law School, where he was senior editor of the Columbia Law Review. Finally, we have Andrew Ullman. Andrew Ullman is the Deputy Assistant to the President and Deputy Director of the National Economic Council. Prior to working at the White House, Mr. Ullman was a partner in the financial services and legislative and government affairs practice groups at Venable, LLP. From 2005 to 2013, he acted as Deputy Staff Director and Chief Counsel for the U.S. Senate Committee on Banking, Housing, and Urban Affairs. Mr. Ullman graduated from Washington and Lee University School of Law and also received his BA from Washington and Lee University. So we're going to kick things off with introductory remarks from each of our three panelists. And Steve drew the straw of going first. So Steve, if you would like to give those remarks, that would be very helpful.
Great. Well, thanks a lot, Jeff. Wonderful to be here. Always great to come back to DOJ and terrific to see the new DAG. This is timely for us because in terms of administrative practice and administrative procedure, we at the Department of Transportation just yesterday, very proudly, posted on our website and sent to the Federal Register what the Washington Post this morning called the Rule on Rules. It is a comprehensive statement of all of the current rulemaking policies and procedures that we apply at DOT. And it's on our website, publicly available. It's going to be codified in the Code of Federal Regulations. In addition to rulemaking procedures, it also addresses the review and clearance and use of guidance documents. And thirdly, it addresses our enforcement actions, putting in place policies and procedures to ensure due process in the department's enforcement actions. So all three of these procedural areas are combined into one mega rule, if you will, which is a very public statement, very detailed statement, and comprehensively captures the policy reforms that we've put in place during the current administration. It's actually not a new set of policies and procedures for us. About a year ago, we published on our website a departmental order on our rulemaking procedures, and also 2 general counsel memos, one on guidance documents and one on enforcement actions. And the rule that we published yesterday codifies all of these reforms into a more formal form as a published regulation that's going to go in the CFR. But it also goes further and makes some tweaks and updates to our policies to reflect the requirements of the executive orders that the President issued just a few weeks ago on use of guidance documents and on enforcement actions. And just to summarize very quickly what you'll see when you look at this rule on rules with regard to rulemaking. Let me focus first on rulemaking. Maybe later we can talk about guidance documents. But on rulemaking, the reforms you'll see, which we follow at DOT, include several areas. Number one, it sets out very clearly our policies for rulemaking, the fact that there should be no more rules than are necessary, the fact that rules should address market failures unless there's some compelling safety need or there's a statutory requirement, the fact that we strive to ensure that the benefits of rules outweigh the costs, that we look to the most cost-effective alternatives in our rulemaking and try to impose the least burden to achieve the regulatory goal. It also sets forth the structure, captures the structure that we put in place, and this is pursuant to the President's executive orders on rulemaking that he introduced at the beginning of the administration, the 2-for-1 requirement for 2 deregulatory actions for each new significant regulatory rule, and also the regulatory reform task force structure, which we've taken to heart at DOT, taken it very seriously, initially under Jeff Rosen's leadership there when he was Deputy Secretary, and we've carried that on where we have a very active RRTF structure, and every single rule at the department, whether significant or non-significant, now gets approved by the General Counsel and by the Secretary. So that's something that is just fundamentally an important reform. And so that whole structure of the RRTF and that process you'll see set out in the regulation and now institutionalized. We hope it will become more permanent as a result of this rulemaking. We also have introduced in the rule, captured our policies on providing greater process for the most high-impact rules so that there's more opportunity for public participation, more opportunities for public comment, and the potential for formal hearings with regard to material issues of fact that are disputed in a rulemaking and may have a significant effect on the outcome of the rule-making determinations. So those procedures you'll see in the rule, and some of those ideas will look familiar to those of you who know about the Regulatory Accountability Act, a legislative proposal that actually passed the House of Representatives and has been under serious consideration for some time in Congress. We've taken some of the good ideas from that legislative proposal and made them a matter of administrative procedure and policy at DOT. So we're really proud of this. We think it's a model for the executive branch and very much carries forward the President's emphasis on regulatory reform and the initiatives of the Trump administration, which are really having, we think, a very significant positive impact on the U.S. economy. Thanks.
Thanks, Steve. Eric, your remarks?
Yeah. Again, thank you all here at Department of Justice for hosting us here today. I think this is very timely. Actually, it's very timely just because DOT has come out with this good new rule that is actually very similar to something that we're sort of working on at HHS, but they've stolen a march on us at transportation, but we'll get there. Obviously, as you heard from the introduction, this is a particular passion of mine, is administrative law and regulation. I was a regulatory policy officer, position that was canceled under the previous administration. When I was there under President Bush, I'm now Chief Regulatory Officer again. I was actually Deputy General Counsel for Regulations, was my first position at HHS. And as I said, I taught regulatory administrative law at Loyola. I was a regulatory lawyer at Greenberg Traurig in the healthcare department before I came back into administration. So one of the things we focused on is, again, some of the regulatory initiatives that are new to this administration. HHS, I'm going to do a little bragging here. Fiscal year 18, we accounted for over half the regulatory savings for the entire federal government, $12 billion. Fiscal year 19, we're again the leader on deregulatory savings, and we're 6 for 1 on our regulatory versus our deregulatory actions. So I think we're kind of leading the pack so far. I think DOT might beat us if they get some of their stuff done this year. We have really no chance, even though we're the largest department, $1.3 trillion budget. But still, nevertheless, I think DOT has a good chance of beating us thanks to Jeff's good work preparing and Steve's continuing work on that. So we're gonna do our best keeping up with transportation this year.
It's a healthy competition.
It's a healthy competition. You can ask Pat Pizzella at Labor. We came in on September 30th with a new deregulatory action to beat Labor this year at the last second. They put something on September 27th. We came in on September 30th. But it's that kind of competition. I think that's necessary when you see the overgrowth of many of the regulations that have lain fallow and building on themselves for a period of decades, that it's frankly healthy to the system to have a new approach to administration and to regulation, and that we do think about these things. We think about the costs, and we participate in some informal competition in some ways, but it's informal. We still have a lot of laws to administer, and we have to do it in a thoughtful way, respectful of the laws that we have to enforce. Part of that, we're doing something that we've done on a particular issue is I have the Deputy Secretary's regulatory sprint to coordinated care, where I'm sponsoring a regulatory reform initiative across 4 different regulatory regimes within HHS: the anti-kickback statute, the Stark law, which deals with physician self-referral, HIPAA, and 42 CFR Part 2, which is a substance use confidentiality statute. In many cases, these regulations had not been reformed or even looked at for 20 or 30 years, and had really stymied some of the transition away from the old model that we're really 3 administrations have tried to get away from, which is fee-for-service in Medicare, onto what we call value-based care system. Coordinated care, meaning patients can kind of go from one care setting to another, is something that a lot of well-meaning statutes had stymied, and so we're working on undoing that and really getting 4 agencies to work with one another across a range of coordinated care is itself a matter of coordination. So it's getting elephants to dance in a regulatory way, which is been an interesting endeavor. And so we've got 3 of those 4 done at this point. HIPAA still remains. I've read the NPRM. And we've done a good amount of internal changes within HHS. For example, I now get a pre-development memo before we ever start drafting an NPRM to kind of look through what an agency is proposing. So we've put new processes in place to make sure that we're thinking about it before we launch a new proposed regulation. And again, we have an RRTF, Regulatory Reform Task Force, similar to DOT, that also looks at these things at a more granular level before they come in to us. So we're very happy to be participating in this, and I think that we've got, within the administration, we've got a good aim at regulatory reform that has, I think, really enlivened a lot of the conversations, at least inside HHS and I think administration-wide, on achieving the right balance of regulation over the industries that we oversee. In our case, it's well over a quarter of the American economy, whether it's FDA, Medicare, Medicaid, or what have you, and the largest single department. So it's a tremendous endeavor, but at least we have the wind in our sails from the point of view of administrative reform and regulatory reform specifically. So look forward to this discussion.
Eric, thanks a lot. Andrew, you're up.
Thank you for having me here today, and really appreciate the opportunity to talk about what the administration's doing on regulatory reform, and particularly how it is impacted by Administrative Procedures Act and potential reform for APA. You know, we at the NEC are the body that's responsible for helping to devise and coordinate the administration's economic policies. So we work with the agents, all of the agencies across the board, and have a kind of, as a result, it's a great place to kind of see perspective on how regulation works and is implemented. And for us, we believe regulation and improving the quality of regulation is essential to our mission, which is improving the economic growth rate for the United States. That's our primary objective at the NEC. And when we think about the impact regulation has on the economy, it becomes very obvious that having a better regulatory process, to have better regulations and potentially have fewer regulations is good for the economy. If we look at the U.S. economy right now, we are growing at a rate that's basically double the rest of the Western world. And you ask yourselves, why is our performance so much better? And if you look at the job numbers today, which are just, I just got to say, just take a minute to do a quick victory lap, just a blockbuster number we're very proud of. We blew expectations out of the water. And it shows that the United States economy still continues to be the most robust and dynamic place to do business in the world. But we know that in order to keep our amazing economy going and really improve the growth rate from where it's at, we still need to do a lot of reforms. We still think we can do better. And one of those areas is improving our regulatory process. And why is that so important? Certainly you've already heard today about the overall cost of regulations on the U.S. economy. You know, by some estimates it's about $1.9 trillion, which is more, just for comparison, than federal tax receipts. So when we talk about impact on the economy, regulation is front and center. Certainly that hits all businesses, it hits all consumers, and when there are inefficiencies there, we all pay for it in terms of not only higher costs, deadweight costs to society, fewer goods and services, fewer jobs. But one area that I think doesn't get enough attention, that we at the NEC have a particular focus on, and why we're very interested in making sure we have a better regulatory process, is the impact on entrepreneurs, who are really the turbine engines of the U.S. economy. And entrepreneurs are the ones who come up with our new ideas, the new innovations that really spur the U.S. economy on. And it's what, our entrepreneurial culture is what differentiates the United States from pretty much every other major industrialized economy. We just had this amazing entrepreneurial culture where any American can look out and say, I'm going to start a business, whether that's going to be a small business in their local community, a gas station, a bowling alley, pizza parlor, or a new tech company that in 10 years will be a global big public company. Entrepreneurship as a culture is one of the strengths of the U.S. economy, but it's also something that's greatly impacted by regulations that are overly broad and not well thought out, because they can impose unnecessary and in many cases overly burdensome regulations on entrepreneurs to make it impossible for them to get their new ventures off the ground. And that in the long term really hurts economic growth. So when we think about regulation, we are really in particularly thinking about those entrepreneurs and how those regulations will be impacted by them. Certainly larger companies, we want to make sure that regulations are workable. But they tend to have a little bit easier time to amortizing some of the regulatory costs, whereas entrepreneurs, it can be a binary. Either I can comply, if the regulation goes through, I'm out of business, or I can't get my new venture up. And also the impact on regulation can have on competition. Because if those entrepreneurs aren't able to get up and compete, that means we have less competitive and less dynamic markets. So having really good regulation is critical for our mission at the NEC. So I'll quickly just want to show you some of the things that we've been able to do to improve the quality regulation. The first thing is we've been aggressive advocates of the use of the Congressional Review Act. I think we are now up to 17 or 18 CRAs. I've kind of lost track. We've used it so often. The President signed so many of them. Before this administration, there had only been one. So that's one, is just taking care of overhanging regulation that has already been out there. Second is the President has signed 2 executive orders, which are mentioned earlier, clarifying how the use of guidance, clarifying the use of guidance, both in enforcement matters, but also in how the process, revising the process for the issuance of guidance, so that guidance will no longer be viewed by the public or by agencies as a de facto rule that hasn't gone through the APA. APA is really important for making sure that an economy of 300 million people, that is at 30 million businesses and incredibly diverse, that regulators are acting in an informed process, and without making sure we understand on how regulation impacts the economy through that public notice process, we oftentimes get regulation that unnecessarily has an adverse impact when it doesn't need to be. And issuing guidance that doesn't have that safeguard creates a really dangerous way for agencies to work. And then 2 final things I'll just mention, because I think they're worth noting, is the federal financial regulators also issued a really interesting interagency document on their view on guidance that reflects very much the tone of the EO. And then finally, the FDIC just last month issued an RFI that is worth looking at, that requests comments on how they should redo their regulatory analysis and focus it and streamline that process so that they have better public comments, and also that their regulatory analysis is more focused on their core missions. For example, they ask for how they can analyze rules better, to make sure that they don't have an adverse impact on safety and soundness, or on access to credit for underserved communities. In other words, how do they improve their regulatory analysis so it actually serves the mission of the agency better? Those are just a couple of the areas that we've been working on improving our regulatory process, and we're very excited also about the work both HHS and DOT are doing to fulfill the President's wishes on this topic. So thank you.
Thanks a lot, Andrew, for your remarks as well. So the first question I have is going to go to Steve, and I'm going to riff off of one of the things you said in particular about your meta rule, your rule on rule. So you have just a wide array of proposed rules or final rules that run the gamut from airport safety, pilot training, medevac pilot training, bridge inspection standards, alcohol and drug testing, fuel efficiency standards for a range of vehicles, and pipeline and hazardous materials safety. So the first part of the question is, how do you prioritize that? Is the rule on rules, does that help you to do that? And then the riff off of something you said, which I found particularly intriguing in terms of trying to modernize the APA, is to ask the fundamental question before you start regulating, what is the market failure that you're trying to address? Because I've found that that's a problem, right? I mean, that's a methodology, a way of looking at regulatory issues that came into being after the APA. There was a lot of optimism in the New Deal stage about having technocrats address issues that Congress was seen as not really able to address. But I think in the 70s and the 80s came economic critiques, and those economic critiques tried to ask the fundamental question of, what do we really need this regulation for? So that's the first question for you, Steve.
Well, thanks. Well, one of Secretary Chow's big priorities coming in as Secretary of Transportation is to centralize review and harmonize review of rulemaking and enforcement decisions across the various what we call modes of DOT. There are operating administrations. As you referenced, we have a wide range of operating administrations, mostly addressing safety regulation of different transportation modes in the country: aviation, railroads, motor carriers, manufacturing of motor vehicle equipment. transit authorities, et cetera. So there's a wide range, and these represent different statutory authorities Congress has granted mostly to the Secretary of Transportation that have then been delegated down to these different operating administrations. But they are not independent actors that operate independently of the review by the Secretary. So one of the things that we really, I think, have institutionalized in this new rule on rules and in the procedures we put in place in the last 3 years at DOT is to ensure greater accountability through the Office of the Secretary, high-level review and coordination of the different rulemaking and enforcement actions across the modes. Now, an equally high priority, actually the number one priority for the Secretary, is safety and achieving the safety mission efficiently and effectively that Congress has granted to the department. So that goes hand in hand with regulatory reform decisions. But when you have a coordinated senior level review working closely with the administrators of the different operating administrations through the Regulatory Reform Task Force and ultimately secretarial sign-off on each action, you really have the ability to see across this varied landscape of enforcement authorities and ensure rational coordination. And so that we're not working at cross purposes in trying to achieve that critical safety mission by taking different regulatory approaches that are sending confusing messages. Now, obviously, if we have a mandate or a critical safety need in one area, that's going to take precedence over regulatory reform objectives or coordination. But the act of synthesizing and reviewing in a coordinated way has real benefits in terms of achieving more efficiency and better compliance results in the safety mission. And that just can't be denied. When you eliminate rules that are economically irrational, that do not produce more benefits than the costs they impose, that may be hard to understand, they may be duplicative of other regulatory requirements, you are going to have a negative effect on safety compliance. Rather, if you clean up those irrationalities, eliminate duplication, focus in on requirements that are economically sound and that are written in plain English and clear to understand for the average regulated entity or person out there in the economy, you're going to achieve higher levels of safety compliance. So we really see, and I think the Secretary has emphasized this, we see a hand-in-glove fit between our regulatory reform efforts and our safety mission. I just want to say, kind of institutionally, one thing we've done as a kind of working approach to the question you raise is we actually, at least for internal management administration purposes, have applied the 2-for-1 requirement of the President's executive order mode by mode at DOT. So when we work through the Regulatory Reform Task Force with each mode, each operating administration, we try to identify 2 deregulatory actions that operating administration can propose to take in conjunction with each new significant regulatory rule. Now, it doesn't always work out that way, and it's not a hard and fast requirement. It's just a discipline. It's really just a mindset and a discipline that helps us unify that effort across the department and achieve more consistency, and I think for that reason, effectiveness. Thanks.
Thanks, Steve. So, Eric, the second question goes to you. On November 1st of this year, you issued a proposed rule informing the public that certain regulatory provisions in the Uniform Administrative Requirements, cost principles, and audit requirements for HHS awards will not be enforced because of serious concerns regarding the prior administration's implementation of the Regulatory Flexibility Act. The Regulatory Flexibility Act, passed in 1980, was one of the earliest attempts to balance social goals and federal regulation with the needs and capabilities of small business, and I think is part of that wave that came in the 70s and 80s of recognizing that one needs to look at costs and market failures. The act has saved small businesses hundreds of billions of dollars over the decades by seeking to ensure that the federal government regulates at a scale that's appropriate to the size of smaller businesses. What prompted HHS to issue that proposed rule, and how can we more effectively use the Reg Flex Act to ensure that we regulate at an appropriate scale?
Well, I think we have undertaken kind of a very serious look at all of our regulations at HHS. We've even, believe it or not, we've put all of our regulations on through an AI at HHS. We fed them all in, and one of the things that we're doing is that we found on the first pass, we did kind of a machine learning process on our regulations, and at the first pass we found that we had broken cross-references. We had laws that we had regulations about that don't exist anymore. We had orphan regs that had never been assigned to an agency. We still had requirements for using the telegram or telegraph. We had still requirements for posting at the General Post Office, which I've been to near us, and there are no HHS notices to the public being posted at the General Post Office. So there were a lot of these requirements for triplicate and quadruplicate paper filings with the department that were no longer being enforced. So we're going to be coming out with kind of we found just on the first pass, we found 1,200 of these kind of like problems within our regulations. We're going to be working on that. It's actually a more complicated process when you have a lot of agencies. They all kind of have to, are we going to actually file it in one big issue? We're going to break some off. Are we going to make the agencies do them and all of them do them? We're going to do it through the secretary. It's more complicated than it seems to draft a preamble for 1,200 regulations changes. It's a very complicated process. But that, I think what I'm doesn't exactly address your question, but the question, what we did with the RFA, is that we have undertaken a look at a lot of the things that have been done, and in the waning hours of any administration, and certainly the previous one, there were certain times that RFA or other rules, even the RFA, which in many ways people have undertaken, sometimes do it in a cursory manner. But if you look at it, some of these were not done. We've had serious concerns about whether the RFA had been followed at all with regard to that regulation, which means by its terms that it was void 180 days after it was promulgated. So in some ways it was a recognition that the rule wasn't in place at that time. It was already lapsed in the middle of 2017. So in some ways we were going to repromulgate that. It's a grants regulation that needed to be in place. We repromulgated most of the provisions of that, but made sure that we took account of some of that we took account with all applicable Supreme Court precedent. There were a lot of things in that rule that had some concerns about their adequate accommodation to other laws and to all applicable Supreme Court precedents. So we made sure that when we repromulgated that it's going to take all of those things into account, that we actually follow the RFA. I mean, as you noted, the law is there to make sure that we regulate at an appropriate scale. And when you have regulatory agencies that span everything from healthcare through food and drug regulation, through research, medical research, social services, the whole area that we regulate is pretty vast. And to have a fundamental regulation that didn't really address a major concern of small businesses that are definitely going to be affected by us, we had to make sure that we had that assessment done. And so we're having to repromulgate the regulation. In some ways, we would have done that anyway, because we knew that there were protections that were not addressed in that grants regulation, particularly with regard to religious liberty, that had not been addressed in that regulation, and that had to be addressed. And so we both accommodated, make sure that RFA is addressed, that we take that seriously, which had to be taken seriously, that we address the fact that by its terms, the regulation didn't exist. We believed that we had strong concerns about it, and that we made sure that all of the laws that we addressed all those concerns. So that was the idea. I mean, we've been prompted to kind of look back on regulations generally, and some of that is needful. So that was one of the ones that got kind of addressed when we found something that was fairly serious non-addressing of the RFA.
Well, it's great to hear, especially about your efforts not only to breathe life into the RegFlex process, but also to use AI, right, to show that government can keep up to date with what's happening, in the larger dynamic area of the American economy.
Yeah, and at least in some ways, I mean, how many teams of lawyers would we have had to put on that to read all of our regulations across FDA, Medicare, Medicaid, and everything? Instead, the AI, at least in its limited way, when we tell it what to look for, could find these things relatively quickly.
Right. No, it's a perfect use of it. It can't do the deeper thinking, but that kind of thing is excellent.
Yeah.
Well, Andrew, the next question is for you, and it won't surprise you that it's going to be about cost-benefit analysis. And so the weighing of costs and benefits has been a key part of the federal rulemaking process ever since President Reagan issued Executive Order 12291 in 1981. And yet there are still some regulations, rulemakings that are done without weighing benefits and costs. For instance, where the agency questions its authority to do so. The Supreme Court has insisted on cost-benefit analysis in several cases in recent years, including Entergy v. Riverkeeper from 2009 and Michigan v. EPA in 2015. Should cost-benefit analysis be required across the board as part of the default rulemaking process that agencies apply? And how can agencies use cost-benefit analysis and other economic tools to improve their rulemaking process?
Yeah. At the core, cost-benefit analysis, in my view, is making sure that there's an informed decision. Most of the rules, the vast majority of the rules that are issued involve some type of financial impact, obligation on parties, or otherwise impact on the economy. And one of the key principles, I think, of a democratic society is that government doesn't act in an arbitrary and capricious way, and that the public has the right to expect that its government goes off and informs itself before it acts. That, to me, seems to be at a very fundamental level, something that we should and rightfully expect from any government actor to comply with, absent unique circumstances. Because it's very difficult to come up with these rules without first going off and asking some basic questions about which parties would be affected, how would they comply. The basic work to put together a rule to accomplish whatever statutory mandate is going to require you to go off and ask the same types of questions and collect that type of information. So you're going to be collecting that information to come up with the rule. It's hard for me to see in most cases on why an agency wouldn't then use that information to make sure that they're moving in the most cost-benefit, the most efficient manner possible. That's just a basic good government approach. And it also, from the public's perspective, and this is where kind of also from the economic perspective, the ability then to weigh in is part of the notice and comment period that the APA provides. It gives agencies then the ability to modify their rules so that they can still hit their statutory objective, but also avoid unintended consequences on particular parties. And that's really a really important part of where cost-benefit analysis, in my view, comes in. Kind of linking up what I mentioned earlier about the impact of entrepreneurs. There are the unintended consequences of regulations can be huge. We have such a diverse economy here. It is just amazing to me on how many people have businesses that interact with federal regulations in ways that you can't anticipate. And this is where I think cost-benefit analysis also requires regulators to have a little bit of humility about their ability to understand the impact of their regulations. There is this idea, kind of going back to the progressive era, that you would have really smart regulators who would go in and look at all the data, and based on that, they would come up with the scientific rule that would be kind of perfect, and that there'd be only one answer. But I think anybody who's worked in government over the last 100 years, since that progressive approach was first promulgated, knows that there are a lot of important trade-offs that need to be made. And that rules have an impact that regulators may not actually be aware of. No one person can really understand the U.S. economy. And so having a robust notice and comment period where regulators can see from the public the impact of their rule is really important. As I mentioned, in my bio, I worked at the Senate Banking Committee for a long time, and particularly I was there during the Dodd-Frank rule regulations were coming through, and now that's a 10-year plus. Thankfully, it's still going on, right? 10-year regulatory reform process, and having the APA requirement that all these rules go through notice and comment has been very, I think, helpful to that process in mitigating some real problems with the Act to begin with. But there's no doubt that the notice and comment provisions there have helped a lot of those regulations avoid a lot of adverse impacts on parties that otherwise would have been otherwise wouldn't have been mitigated. So I think we just owe it to the public to have a cost-benefit analysis. It improves the rule. The downside, I think, is very minimal. And it's something that the public benefits from, and also simply makes us do our work better. The one last comment I'd also put on that the cost-benefit analysis is that it actually does also, I think, helps come up with a unified approach through the federal government, because we have so many agencies, so many different rulemaking authorities out there as part of the OIRA process, which tries to centralize and come up with a consistent approach. Cost-benefit analysis is core to that, to making sure that any administration has a consistent, can have a consistent, coherent policies across the federal government. And so therefore, naturally, I think it's cost-benefit analysis is a really valuable tool for regulatory agencies.
Thanks, Andrew. I mean, we heard from Dan Flores, who was on the immediately prior panel, that the regulatory costs of this nation are equivalent to the 9th largest nation by GDP, and it would seem that inherent in that would be you have to have some transparency, otherwise those costs would be hidden, right? That can't be rational decision making.
And then to try and mitigate them too. If you can achieve a statutory mandate in a cheaper way, what's the argument for not doing that, right? It has to be pretty substantial. And again, just informing yourself in a reasonable manner is an important value. Certainly, there's regulators have to make decisions, and that there's an information collection kind of process that has to come to an end at some point, right? But at least the notice and comment period there will help inform the regulators to get the best information they can, along with their own analysis, put it out for the public, get comment on it, and then they can make a decision and move along. When you have regulations that have billions and billions of dollars of impact, that's a small kind of transaction cost to making sure that that regulation is done in the most efficient manner.
Absolutely. So I have some general questions. First, I think I would commend to everyone in attendance and the other panelists looking at DOT's rule on rules, which I think would prove a model for administrative law reform, and I think is consistent with the title of this panel, which is about best practices of the current administration. But I want to talk about another set of best practices. In part, it's about implementation inside your two agencies, and then, for Andrew, for him, the form of the question would be participating in the development of this. But President Trump, and it's been referred to several times earlier today, has signed 2 executive orders that are aimed at curtailing agency abuse of guidance documents. The first EO was called Promoting the Rule of Law Through Improved Agency Guidance Documents. It increases transparency around guidance documents. It requires federal agencies to establish a repository page on their website where all of the agency's guidance documents can be found. And the second EO is called Promoting the Rule of Law Through Transparency and Fairness in Civil Administrative Enforcement and Adjudication. It deals with penalties stemming from guidance documents and other unannounced policy interpretations. So for those in the chairs of running the substantive agencies, how do you make use of informal guidance as a tool for informing the public and regulated entities? To what extent do you do that? How has your agency sought to strike the appropriate balance between the benefits of guidance and its harmful aspects? there I guess I'd refer you to Professor Perillo's remarks from the first panel about his study trying to look at those kinds of trade-offs. And finally, what can be done to assure that guidance documents are not misused? Whoever wants to kick it off.
Great, thanks. Well, I love this topic. Kind of an easy answer because it's also covered by our rule on rules regulation. As I mentioned at the beginning, it has 3 areas it addresses: rulemaking procedures, but also review and clearance of guidance documents, and due process and enforcement actions. So the last 2 get into the subject you're talking about in there, the subject also of the President's executive orders from a few weeks ago. So just as a reminder to everyone up front, guidance documents can be extremely helpful to regulated community because they provide information. They can be a positive regulatory tool in terms of giving regulated entities a clearer idea of what's expected for purposes of compliance with an existing law or regulation. The critical thing is they be published and known. Multiple critical things, okay? Number 1, they be published and known to all potentially interested affected parties. Number 2, they do not impose new legal obligations in their own right that go beyond existing statutory obligations or regulations. Number 3, they're not used in an enforcement action as an independent basis to penalize somebody. So in other words, their advice, they're precatory, they're giving you helpful instructions as to what the regulator thinks is a good way to go. But they're not in and of themselves legally binding beyond what's in existing rule or regulation. And then the last point is that we recognize that as helpful as they may be, guidance documents can impose as a practical matter or can result in, I guess is the right way to say it, real economic costs out in the economy for private parties. Because just face it, let's say, the regulator is regulating the financial accounting of certain entities, and the regulation says you have to have sound financial accounting for your business in place. And then they put out a guidance document, and the guidance document very helpfully says, if you hire 2 independent financial accountants to do your books, we'll treat that as a safe harbor, and we won't bring any enforcement action. So it's basically a should. It's not required, it's a should. All right, so we have to face the fact that a lot of regulated entities will take that and they'll expend money to follow that suggestion because they want to avoid the potential for an enforcement action, let's say. So there's going to be a number of entities, probably a pretty predictable number, who don't currently use 2 sets of accountants to do their books, who will go out and incur that cost just to come into compliance with what the guidance says the agency thinks they should do as a good compliance practice. So that is a real cost, and it should be accounted for. And so the other principle, the final principle, is when there's good reason to believe, and the agency should know this, that a guidance document is likely to result in significant costs to the economy, and just use the $100 million annual cost that is used for significant rulemaking by OIRA, then the agency should do a cost-benefit analysis and should put that guidance document out for public comment. Now, maybe it doesn't have to be published in the Federal Register. Maybe you could use a more informal process. But these are the elements that we've got in our procedures. We put them in place a year ago, and they're also reflected in the President's executive order. All guidance documents are now put on the website. So everybody who's affected can see what the operative guidance is. It's clearly stated in the guidance document that it does not have force and effect of law in its own right and won't be used as a basis for an enforcement action. We try to avoid using shall and must in the guidance documents. Rather, it should or may consider, et cetera. And then if there's reason to think it'll have significant costs, we do cost-benefit analysis. We put it out for public comment. And these are some of the same elements that the president has instructed agencies to follow in the executive order of a few weeks ago. So we think that, that won't, guidance can be very positive and useful. It shouldn't be eliminated, but if done in the right way, these are fundamentally important reforms. And then just the last thing I'll say about enforcement actions is, as you'll see again in our regulation on enforcement actions, we should be upfront, open, transparent as to what the legal requirements are we expect of parties before we go in and do inspections and bring enforcement actions against them in an attempt to penalize parties. It's just fundamental due process. Give them notice, and then an opportunity to be heard in an enforcement action. Don't play gotcha. We also, as you'll see in there, we're not going to use the Chevron doctrine of judicial deference as an excuse or device to expand the envelope and go as far as we can go on what our authorities will allow for in an enforcement action. We're going to stick to what is a reasonable best interpretation of the authority. And so again, these are just fundamental. We have some other interesting reforms in there. Some in DOJ may be interested to see. As a matter of enforcement policy at DOT, we're actually going to apply a version of the Brady Rule in the administrative enforcement context. That is to say, consistent with the integrity of the enforcement effort, we will share with the regulated entity the material evidence we have on both sides of the issue before trying to bring the hammer down for a violation. Thanks.
Yes, thanks. Eric, do you want to take that?
Yeah. So HHS, no stranger to guidance and informal guidance documents. It is very widespread within our agencies. As many of you may know, there's a recent Supreme Court case involving Medicare on this very issue. Allina Health Services, that was decided earlier this year, found that the notice and comment requirements were different in the Medicare Act and in the APA. And now, while some interpretive rules were exempted from notice and comment rulemaking under the APA, they weren't under the Medicare Act. And so we're actually having to kind of revise the procedures of our sort of largest single program to reflect the fact that guidance is going to be treated differently in that area in accordance with the Supreme Court decision on that. So we have to undergo much stronger amount of notice and comment process for Medicare. So that is kind of radiating through the department right now, is the fact that we have these new requirements under Allina. To echo what Steve said, we also have the fact that for us, pharmaceutical companies, medical device companies, food and beverage companies, hospitals, doctors, all healthcare providers, one way or another, usually participate some way in one of our agencies, and they need guidance in that informal way. Nevertheless, the impact of it is huge. Even the markers that you put down, $100 million in the context of our programs, kind of sweeps in an enormous amount of material from an HHS point of view, just because the dollar amounts that we deal with in the healthcare sector are so large for a multi-trillion-dollar sector of the economy. So it's a bar for some areas, I think, and in some agencies, but it sweeps a lot of material into our process. Necessarily so, I think. I mean, the impact that we're talking about is vast, but it's also necessary that we approach guidance in a new way. So I would say watch this space. We're probably a little bit behind DOT in this area in just terms of timing for us to get around to this, but we're both acting under Supreme Court direction in the Allina case, where we're going to have to comply with new requirements on us in the Medicare context, and also the two EOs that I think provide a very useful amount of direction for us to kind of put this in place. The same issue came up under President Bush as well, and OIRA, under the idea of the significant guidances issues that came up under then Director Graham. So we're our team, which was many of us were there before under President Bush, are well aware of the issues. So we're kind of coming back to this issue once again of the role of guidance, the demands for it on the part of industry, because trying to undertake a highly technical and complex, many times scientific or technological issues for industry on the one hand, which have to retain a certain amount of flexibility and a need to kind of move rapidly on the ground, but on the other hand, the amount of money and expense that industry is going to expend on the basis of that guidance is also has to be balanced on that side as well. So it's a complex area, but I would say watch this space. We'll be coming out with something as well, additional safeguards to make sure guidance isn't misused in the future, or that we cabin in some ways the process that we're undertaking at the department.
So Andrew, thank you, Eric. We have about 3 minutes left, so we could have some concluding quick remarks, or you could say something about guidance.
Let me say quickly on guidance then, and is that just for perspective here on what we've been doing, is that if you look at the APA, it was enacted in 1946. Guidance did not simply play the role that it does today in the agency process. And also technology has changed just a little bit since 1946. And that means, communications, the ease of communications and the ability for agencies to put out guidance has really, really increased. In addition, guidance is also something that is increasingly used by professional staff as opposed to appointed and Senate confirmed officials. And so if you look at the reforms that we've implemented through the EOs and that our agencies are now implementing, they do two big things, I think. One is make sure that there's kind of direct accountability within the agencies by requiring that the agency heads sign off on any significant guidance. So we have accountability within the agency. And then two, that it requires significant guidance to go through OIRA, making sure that the president then also has a chance to weigh in and be informed about any significant guidance. If you're having a guidance that's going to have an impact of $100 million or greater, now that's something that we need to have direct accountability for, both within the agency, but also overall from the administration from the president's perspective as well. So we think these both reforms will help improve the accountability and then therefore hopefully the outcome on how we use guidance going forward. And that will also finally be a good thing for the public in making sure transparency and that agency officials don't simply issue guidance without making sure the elected officials are aware of what's going on.
Well, thanks to all of our panel members, and thanks to you for your attention to their comments.
Thank you, panelists, for your remarks and for your leadership on these important reg reform efforts. I would now like to welcome Beth Williams. Beth is the Assistant Attorney General for the Office of Legal Policy, where she helps lead the department's regulatory reform efforts. Before joining the department in 2017, Beth was a litigation and appellate partner at Kirkland & Ellis, and in prior government service, Beth assisted with the confirmations of Chief Justice John Roberts and Associate Justice Samuel Alito to the Supreme Court as special counsel to the Senate Judiciary Committee and clerked for Judge Richard Wesley of the Second Circuit. Beth is a graduate of Harvard College and Harvard Law School. Please join me in welcoming Beth Williams.
Good afternoon. As Dan mentioned, my name is Beth Williams, and I am the Assistant Attorney General for the Office of Legal Policy, or OLP. OLP is often referred to as the think tank at the Department of Justice, and in that capacity, OLP has had the privilege of giving serious thought to the regulatory state and to making sure that our processes at the Department of Justice abide by constitutional principles and the Administrative Procedures Act. As the head of OLP, I serve as the department's Chief Regulatory Officer and Regulatory Policy Officer. I also serve on the department's Regulatory Reform Task Force. In each of these roles, I have been privileged to support the department's efforts to make the regulatory process more transparent, more accountable, and less burdensome for the American people. Today, I have the honor of introducing someone who is a paragon of dedication to these worthwhile goals, our keynote speaker, Deputy Attorney General Jeffrey A. Rosen. I can think of no one better to close out this summit. Confirmed by the Senate on May 16th of this year, Deputy Attorney General Rosen acts as the department's chief operating officer and advises and assists the Attorney General in leading the department's more than 110,000 employees. The Deputy Attorney General brings to the department a wealth of administrative law expertise. From 2003 to 2006, he served as General Counsel of the Department of Transportation. And from 2006 to 2009, he served as General Counsel and Senior Policy Advisor for the White House Office of Management and Budget, the office that coordinates and reviews all significant regulations by federal agencies across the executive branch. Immediately before his present appointment, the Deputy Attorney General served for 2 years as the Deputy Secretary of Transportation, where he was the Chief Operating Officer of that department. There, he oversaw significant regulatory reform initiatives that serve as a model to other agencies. Between his positions in government, he was a partner at Kirkland & Ellis, where I first had the pleasure of working with him and getting to know him. Jeff was a legend at Kirkland, not only for his fearsome litigation skills, but also for his kindness and unmatched work ethic. Associates would take note that one of the last cars to leave the garage at night was the one that was emblazoned with Hockey Dad on the back. From 2015 to 2016, Jeff chaired the Administrative Law and Regulatory Practice section of the ABA. And of particular interest to all of us here at this summit, he has twice testified before Congress on APA reform. Please join me in giving a warm welcome to the 38th Deputy Attorney General of the United States, Jeffrey A. Rosen.
Thank you, Beth, for that very kind introduction and for the great work you do helping to lead the Justice Department's important regulatory reform work. Before I begin, on behalf of the department, I would like to say that our thoughts and prayers are with the victims of a shooting this morning at the Naval Air Station in Pensacola, Florida, because promoting public safety and the rule of law are two of the most critical missions that the Department of Justice undertakes. And success in those priorities is what allows for important events like this summit. So with that said, let me also take a minute to thank the Solicitor General and all of our speakers, moderators, and panelists for their insights today. We've heard many thoughtful ideas for improving the Administrative Procedure Act, and I hope this summit begins a process that leads to many of those ideas becoming law. Every single speaker this morning made, and right up to a few minutes ago, made clear that the Administrative Procedure Act is one of the most important pieces of legislation ever enacted. By prescribing the procedures that agencies must follow in regulating private parties, the APA governs much of the federal government's conduct and affects virtually every American. For these reasons, the APA has been described as a super statute, or as the fundamental charter of the fourth branch, or even as the Constitution of the administrative state. Now, that last description, I have to say, goes too far. The Constitution of the administrative state is the Constitution of the United States. But the APA is celebrated largely because it advances the values of our fundamental charter by making administrative procedure more consistent with principles of due process and the rule of law. Today, it is easy to take these contributions of the APA for granted, but that would be a mistake. The APA's enactment in 1946, as you've heard from a number of the panelists, the APA's enactment followed years of debate over whether and to what extent to put in limits on an administrative state that had grown rapidly during the New Deal. That debate partly pitted the New Deal's supporters against its opponents, but more fundamentally, it pitted a vision of government based on bureaucratic expertise and trust in permanent civil servants against one based on more legal protections of due process, more public input, separation of powers, and focus on rule of law. In the course of that debate, both sides experienced victories and setbacks. As the Solicitor General described, the 1941 Walter Logan Bill, for example, or 1940, I should say, was a strong rebuke to the excesses of the administrative state, but it was vetoed by President Roosevelt. Ultimately, the bill that became the APA firmly established rule of law principles as a check on administrative authority, but it did not decisively settle the broader contest. This history of the APA is itself an important reminder that beneath seemingly dry matters of administrative procedure are really fundamental questions about what values we want the administrative state and government generally to embody. Those questions, if we fast forward 73 years, those questions remain important today because while the APA has not changed much in the 73 years since its passage, administrative procedure and the regulatory state very much have. That was the underlying point of our first panel. The clearest, most consequential example of this change is in informal rulemaking. As our panelists discussed, in the debate over the APA and in the APA itself, informal rulemaking was actually something of an afterthought. In 1946, the main form of regulation was adjudication. And as the former dean of the Harvard Law School, James Landis, wrote, the uppermost problem that led eventually to the passage of the APA was concern about separating agencies' prosecutorial and adjudicatory functions. The 1941 report of the Attorney General's Committee on Administrative Procedure reflected this focus. It devoted more than twice as many pages to adjudication as to rulemaking. Today, of course, the opposite is true. Informal rulemaking is where the action is. Informal rulemaking's day really came with the major health, welfare, and environmental statutes of the 1960s and 1970s, and regulation has never been the same. Informal rulemaking has been the fuel of the administrative state's explosive growth. There's been a considerable amount of discussion about that during the day, but the growth can be measured in several ways. Just to use one metric is the length of each year in the Federal Register where agencies publish proposed rules, final rules, and rules changes. In 1947, as wartime regulation had receded, the Federal Register was, get this, a breezy 8,900 pages. In a speech on the Administrative Procedure Act to a state bar association around that time, the then Attorney General, Tom Clark, felt it necessary to pause in his discussion to observe, and this is a quote, "It occurs to me that some of you may not be acquainted with the Federal Register. Too few lawyers are aware of the existence of this publication," close quote. It is inconceivable that such a public service announcement would be needed today. In 2016, the Federal Register's length peaked at 97,110 pages. Last year, that shrunk by nearly a third, but it was still just over 68,000 pages. The number of new regulations is equally revealing. From 1995 to 2017, agencies issued over 92,000 rules, compared to, for the same time period, just 4,400 newly enacted laws by Congress. So as several of the panelists made clear during their presentations, regulation has now become our principal form of lawmaking. Moreover, the number of regulations tells only part of the story. Just as important has been regulation's scope. In recent years, regulation has often replaced legislation as the tool for resolving fundamental policy questions. Some major regulations issued by past administrations have imposed billions of dollars in costs, affected thousands of jobs, and have sought to decide the course and even the survival of entire industries. These sorts of policy decisions are ones average citizens would rightly expect to be made by politically accountable representatives in Congress, rather than by administrators and agency staff, many of whom are intentionally insulated from accountability to voters. This is partly a problem created by Congress itself through excessive delegation, but it has also been a problem of regulatory overreach in some cases, as regulators in some past administrations sought to bypass Congress by stretching their statutory authority to enact policies that the relevant statutes did not contemplate and that Congress did not contemplate. So, unsurprisingly, the explosive growth in rulemaking has brought into focus additional values that regulation should serve. In recent decades, both Republican and Democratic administrations have recognized the need for the regulatory process to promote economic growth, promote efficiency, enable public voice, have transparency, and provide accountability. President Reagan introduced these themes in his landmark Executive Order 12291, which stressed the need, this is a quote, to reduce the burdens of existing and future regulations, increase agency accountability for regulatory actions, provide for presidential oversight of the regulatory process, minimize duplication and conflict of regulations, and ensure well-reasoned regulations, close quote. Happily, each succeeding administration has carried these principles forward. As is probably known to most folks in this room, in Executive Order 12866, President Clinton called for a regulatory system that protects the public without imposing unacceptable or unreasonable costs on society. EO 12866 recognized, quote, the private sector and private markets are the best engine for economic growth, and that agencies should produce, quote, regulations that are effective, consistent, sensible, and understandable, close quote, through a process that is accessible and open to the public. President Obama echoed these themes in EO 13563, declaring that our regulatory system must allow for public participation and an open exchange of ideas, must promote predictability and reduce uncertainty, and must take into account benefits and costs. In short, for decades, every administration has recognized the need for a better regulatory process, particularly with respect to rulemaking. Yet for decades, the Administrative Procedure Act has been virtually unchanged. This is remarkable. For all of its virtues, the APA is not perfect and never has been. As the Supreme Court observed way back in 1950, the APA, quote, contains many compromises and generalities, no doubt some ambiguities, and experience may reveal defects, close quote, in the statute. That prediction was prescient. Experience has revealed ways that the APA fails to fully achieve the goals of good but limited government. As early as the mid-1950s, the Second Hoover Commission recommended amending the Administrative Procedure Act to make both rulemaking and adjudication more fair and less burdensome. And these concerns have been repeatedly recognized ever since. In his 1960 report to President-elect Kennedy, James Landis wrote that, quote, effective procedural solutions so necessary to the proper functioning of the administrative agencies have admittedly not been achieved, despite the sweeping studies which culminated in the Administrative Procedure Act of 1946, close quote. 2 decades later, in late 1970s, Griffin Bell, who served as Attorney General under President Carter, lamented at what he called overregulation having been, quote, allowed to impede national growth, close quote, and he blamed the problem on Congress's reluctance, quote, to re-examine the functions of any of the regulatory agencies it created or to meaningfully supervise their rulemaking. These critiques have also been reflected in numerous legislative proposals over the decades, hearkening back to Senator Lloyd Benson's 1979 proposal to create a regulatory budget for each agency, to Senator Bob Dole's 1995 proposal to require agencies to revisit old rules and undertake rigorous cost-benefit analysis for new ones, to, as we heard from many of the panelists, the Regulatory Accountability Act, which passed the House of Representatives in several successive Congresses right up to last year. In recent years, interest in updating the Administrative Procedure Act has been widespread. As you've heard earlier today, one of the leading voices originally pushing for enactment of the Administrative Procedure Act in the 1930s and 1940s was the American Bar Association. And in 2016, 70 years after the Administrative Procedure Act's enactment, as Professor Ron Levin explained in his remarks, the American Bar Association House of Delegates adopted in 2016 Resolution 106B, which urges Congress to amend the rulemaking provisions of the APA and identified 9 ways that the APA could be modernized. So happily, as all this suggests, the lack of reform does not result from a lack of ideas. As our panelists discussed today, there are numerous ideas for improving the regulatory process, including some I've offered myself in the past, and some have already been put into practice without legislation. In the absence of legislative reform, the executive branch and the judiciary have, on their own, made numerous changes to how regulation is formulated, enforced, and reviewed. Together, these changes provide at least insight and perhaps a partial menu of things that could be done to modernize the Administrative Procedure Act, particularly with regard to its rulemaking provisions. Let me offer 2 examples of long-standing executive branch improvements to the regulatory process. The first is one we've had some discussion about, and that's centralized review of agency regulation through the Office of Management and Budget. When President Reagan introduced centralized review in Executive Order 12291, 1 month into his administration, he was met with some considerable skepticism. Boyd and Gray, who helped draft that executive order, has recounted that when agency officials first gathered to review the order, heads were shaking vigorously and sidebar conversations were expressing disagreement and skepticism. That is, until, quote, cacophony turned to stunned silence as the officials in attendance, one by one, reached the end of the document they had assumed to be a draft, only to find the signature of Ronald Reagan on the last page. But despite that initial concern or skepticism, over the ensuing years, centralized presidential review so proved its value that every president from both parties and each administration since has embraced it as an essential regulatory tool. Centralized presidential review has enjoyed such support because fundamentally it advances widely shared good governance values that apply to regulation and deregulation alike. Centralized review has improved the regulatory process in numerous ways, including priority setting, consistency, the requirements of analytic steps, and in terms of accountability. And for these reasons, I think it's worth noting that former OIRA administrators of both parties, the Administrative Conference of the United States, and the American Bar Association have all endorsed expansion of centralized review to most independent agencies as well. So that takes me to a second executive branch innovation that has become a crucial feature of centralized review: the use of cost-benefit analysis for major rules. For approximately 40 years, administrations of both parties have used this tool to improve regulation by preventing rules that do more harm than good. I would also note that the basic distinction between major and minor rules, or significant and non-significant rules, as the terminology is in 12866, that distinction is itself an executive branch innovation. Under the Administrative Procedure Act, all legislative rules, no matter how costly or consequential, are governed by the same one-size-fits-all set of procedures. Isn't that itself kind of odd? I thought Professor Walker addressed that a little bit, that conceptually, our jurisprudence has long recognized that before the government can deprive someone of their property, the amount of due process depends in part on the private interest at issue and the probable value of additional procedural safeguards. The same logic should apply to the regulatory process. Some rules impose minor burdens on parties, others impose potentially existential costs. The idea that the latter deserve no more than the former seems absurd, and it's a position every administration for the past 40 years has rejected by separating non-significant from significant rules. So it bears emphasizing that centralized review, cost-benefit analysis, and greater scrutiny of the most costly rules all spring from requirements imposed by the executive branch, and they are not currently part of the Administrative Procedure Act. More recently, the executive branch has developed additional innovations that I want to just briefly highlight as well, because regulatory reform has been one of this administration's highest priorities. Those regulatory reforms began with one of President Trump's first acts in office, which was the issuance of Executive Order 13771. That executive order required agencies to repeal 2 existing regulations for each new one they issued and to impose no new net regulatory costs, which is a goal the administration has exceeded, as we've heard from panelists. Executive Order 13771 is a landmark process reform because it encourages agencies for the first time to adhere to a regulatory budget and to consider the cumulative burden of their regulations on taxpayers. This helps agencies to adopt the most cost-effective approach to regulating and to prioritize the rescission of their most burdensome regulations insofar as taking all these steps is consistent with their statutory obligations. Nothing about the executive order could alter, of course, existing statutory requirements. With regard to the one-in, two-out concept, countries such as the United Kingdom, Canada, and Australia already had similar forms of sometimes one-in, one-out, or one-in, two-out systems for regulations. And now that this is in effect here, the administration's overall deregulatory approach has delivered real reform. The administration has eliminated hundreds of unnecessarily burdensome regulations, netting tens of billions of dollars in regulatory cost savings. In another important reform, as you've heard from at least 2 of the earlier panels, the administration has combated the misuse of guidance documents. In some prior administrations, agencies sometimes used guidance documents as a shortcut around rulemaking requirements. They issued guidance not merely to provide non-binding advice, but to expand the law or change the public's behavior. But making matters worse, agencies sometimes scattered guidance across a range of documents, some of which were difficult for parties to find, and agencies sometimes enforced interpretations of law without adequate public notice of those interpretations. Small businesses, in particular, often found themselves confronted with an unknown and potentially unknowable regulatory regime. This administration is putting an end to those practices. Here at the Department of Justice, in the Sessions and Brand memos, as they've come to be known, the department declared it will not treat noncompliance with other agencies' sub-regulatory guidance as itself a violation of applicable statutes or regulations in civil or criminal enforcement. And then, just 2 months ago, President Trump issued 2 executive orders to further clarify the role of guidance. Those were Executive Orders 13891 and Executive Orders 13892. You've heard a considerable amount about those from the last 2 panels, so I'm not going to go through those in any detail, other than to observe that they will help ensure that administrative proceedings in particular will provide greater protection for Americans' individual rights. Now, in modernizing the Administrative Procedure Act, what about judicial precedents? So-called administrative common law has significantly changed the regulatory process in varied ways. Take the DC Circuit's well-known decision in Portland Cement, imposing a rule that agencies disclose data, studies, and other information on which they intend to rely in their rulemakings. By enabling interested parties to evaluate and, if necessary, challenge the basis of agency decision-making, Portland Cement has pushed rulemakings towards greater rigor and greater accountability. Interestingly, though, one can contrast the Administrative Procedures Act requirement of only a, quote, concise general statement, close quote, with the requirements for notice and comment rulemaking today. In 1947, the Attorney General's manual on the APA opined that under the statutory concise general statement requirement, the manual said, quote, "Findings of fact and conclusions of law are not necessary, nor is there required an elaborate analysis of the rules or the considerations upon which the rules were issued," close quote. Well, that seems to expect less than the courts have. The guidance from 1947, from the Attorney General's manual, was consistent with an overall effort that sort of downplayed the APA's significance, but today the manual's approach is sometimes out of step with later judicial decisions. At the same time, some administrative common law is neither sound law nor sound policy. One recent example of concern, at least, concerns the scope of the administrative record. Under the APA, judicial review must be based on the record compiled in the administrative proceedings at issue. The record, full stop. Accordingly, courts have recognized, at least ordinarily, judicial review is limited to that record and not something else. In the 1970s, however, the Supreme Court posited that there may be rare cases where extra record discovery is appropriate. The court cited no textual basis for this exception, and until recently, the Supreme Court had never actually allowed extra record discovery in a challenge to administrative action. That changed with the census case last June, when the Supreme Court considered extra record evidence, even though all the justices who considered the question agreed that the district court had abused its discretion in ordering such discovery. But now that the Supreme Court has allowed this exception, having said it was an abuse but considered the evidence anyway, litigants will almost certainly try to open a whole new front in APA litigation, albeit one that the APA itself did not appear to contemplate. This highlights that modernizing the Administrative Procedure Act may involve clarifying what is not allowed, as well as adopting improvements as to how the regulatory process should function going forward. Okay, so where does this leave us? The Administrative Procedure Act of 1946 plainly needs to be brought current to 2019. We've heard extensive discussion about possible changes and the reasons for them. The time available today does not allow a full canvas of all the ways the APA might be modernized. But what I've tried to do is to sketch some executive branch and judicial reforms that are suggestive, because even the basic act of codifying existing best practices would be valuable, as it would promote stability and eliminate uncertainty. But ideally, Congress should do even more to modernize the regulatory process. So the key takeaway for today is that it's clear that the Administrative Procedure Act needs modernizing to meet the realities of today's economy and the regulatory state. Let me reiterate that. The Department of Justice unequivocally supports the position that the Administrative Procedure Act of 1946 needs legislative modernization. Fortunately, there are thoughtful voices in Congress who've been working on this. It takes time, and just as DOJ played a vital role with regard to the Walter Logan Bill in the late 1930s and the legislation that became the APA during the 1940s, we are prepared to do so again. The Department of Justice stands firmly in favor of legislating improvements to the APA that would build on the commendable regulatory improvements made since January of 2017. Good administrative procedure is essential to a well-functioning government and to respecting Americans' individual liberties. And we look forward to working with Congress on these vital issues. So for all of you who are here today, we appreciate your engagement, your involvement, your interest, and I thank you for being here with us today. Thank you.